is an open letter to the plaintiff who just found Rule 11 like it's a goddamn Horcrux. Well, there's a moment in every imploding lawsuit where the plaintiff, having run out of facts, coherence, and judicial patience, grabs a hold of a new lifeline: procedure. That's where you're at now. No longer arguing the merits because those have long since been left bleeding on the floor. You've instead turned to citing Rule 11C2 like it's some enchanted cloak of immunity. Well, let's be clear. The issue before the court wasn't a minor flaw. This wasn't a comma out of place or a citation missing italics. The issue was that your entire pleading collapsed under its own weight, as the court politely but unmistakably called it a shotgun complaint, the procedural equivalent of taping dozens of causes of action to a dartboard, blindfolding yourself and hoping that something sticks. And now, after 3 amendments, multiple warnings, and a final judicial order dismissing the case with prejudice, your argument essentially is this: but they didn't give me a Rule 11 warning first. No, that's not how any of this works. That's not how dismissals work, and definitely not how sanctions work when the court itself invited the defendants to file motions for fees after you wasted everyone's time with a complaint that defied the federal rules of civil procedure and gravity at the same fucking time. At no point in this saga did you demonstrate an ability to file a coherent complaint that complied with Rule 8 or Rule 10. Instead, you treated federal court like a creative writing workshop, conflating defendants, repeating vague allegations across dozens of pages, and producing a record so murky the judge couldn't even parse which defendant was supposed to have done what, when, or why. You didn't just miss a few legal standards. No, shithead, you demolished the floor plan of federal pleading entirely, and after being told to clean it up not once, not twice, but repeatedly, you filed another complaint that was just unreadable as the last. So yes, the case was dismissed, not because of some technicality, but because you refused to comply with the foundational structure of litigation. So let's get to the meat of it. Rule 11C2. It requires a safe harbor, a notice before a motion for sanctions is filed. True, but guess what? That only applies to party-initiated sanctions. The court, which you seem to forget is not some passive referee in all of this, is permitted to act on its own initiative under Rule 11C3. Yeah. Now you cling on to Rule 11C5b, which limits court's ability to impose monetary sanctions on its own initiative unless it first issues a show cause order before voluntary dismissal or settlement. But here's the problem, dipshit. That doesn't apply when the court is acting post-dismissal in response to a fully adjudicated motion, especially when it was the court itself that told the defendants to file it. Well, let's not forget, you didn't voluntarily dismiss the case. You got your ass benched permanently. The judge didn't say, thanks for playing. He said, don't come back with this bullshit. So no, 11C5b isn't your golden ticket. The safe harbor clock doesn't run after you've already sunk the ship. The ruling was clear. If the shotgun complaint hadn't doomed your case, the court would still have dismissed the federal RICO claim for failure to state a claim and then decline to exercise supplemental jurisdiction over the state law claims. You were never surviving summary judgment. You weren't surviving a second read-through. The idea that this was a close call is laughable. It was a procedural and factual failure from the opening paragraph, and now you want to squabble over whether the court checked the right Rule 11 checkbox before asking the defendants to itemize their wasted time that you wasted. Let's address that, because you don't just oppose the sanctions. You want to relitigate the entire basis for them by citing Royal Palm versus Slider and Crosspoint like they're binding shields. But in those cases, the complaints were at least legally intelligible. Yours? it was bullshit. Slider involved a motions fees that lack specificity, but in your case, the court doesn't need speculation. It's got an entire docket full of incoherence, delays, vague threats, amended complaints that read like cut and paste jobs from unrelated briefs. Even if your appeal is accepted, and generous if, that does not undo the procedural abuse already documented. The statute allows for attorney's fees after a trial judgment and the exhaustion of appeals, and that's collection. It doesn't bar the calculation or awarding those fees now. You don't get to use an appeal as a litigation freeze ray. You can't lose at trial, appeal the loss, and then act like the opposing party's right to seek fees is suddenly under ice for 18 months while you slow roll a rehearing request that you know won't land. The fees aren't premature. The damage is done. You filed a structurally broken case, ignored every warning, and now that you've lost, you want to blame the other side for not alerting you to your own incompetence fast enough? What you filed was not coherent complaint. It was a Rube Goldberg device made of vague accusations, cut-rate civil conspiracy, and procedural confusion. When the judge told you to clean it up, you handed him a bigger pile of shit. And when the court finally slammed the doors shut, your instinct was to say, "But they didn't file a letter." Dude, it's not the court's job to save you from yourself. This is not the defendant's job to educate you on the rules. It's not Rule 11's job to be your scapegoat. The motion wasn't improper. The dismissal wasn't unfair. You just simply lost, and badly. So let's not pretend the order's been signed yet. Let's pretend that order hasn't been signed yet. The gavel hasn't hit the wood yet. But if you think the judge sat through 3 rounds of pleading malpractice, issued a dismissal with prejudice, invited the defendants to tally the bill, and isn't going to grant those sanctions, buddy, I've seen more suspense in a weather forecast. The only thing undecided is whether the footnote will include the phrase abject waste of judicial resources or just a polite nod to egregious procedural abuse. So before that hammer falls, maybe ask yourself this: do you have any money to pay for this? We've heard whispers, bankruptcy chatter, shifting foreclosure narratives, maybe even a lawyer or two that's mysteriously vanished after catching a whiff of an invoice. You're trying to stall, appeal, and out-procedure the inevitable, but sanctions, well, they don't give a shit about your balance sheet. They're like gravity. They land whether you're ready or not. When that order drops, I just hope you've got something left in the tank, because Rule 11 doesn't come with a layaway plan. That all depends on whether an appeal court even takes your bullshit case. Respectfully submitted, Shizzywhiznut. Velcro advocate for coherent pleadings, JD from the School of Consequences, and court-certified handler of anti-litigation delusions, and most definitely your daddy.
It is about time. Let's break this mother down. With Shizzywhiznut.